So, this is the courtroom. My fate will define here.
Assalamualaikum warahmatullahi wabarakatuh. Trial of the District Court of Atas Awan which examined and adjudicated criminal case of corruption in the first instance with the usual proceedings under case number 438/001/14/F/03/2008 with defendant Tegar Gemilang on this day, 14th December 2022, it was opened and declared open the prosecutor.
Court hearing, Negeri Atas Awan, which examines and adjudicates criminal cases of corruption in the first degree with ordinary examination with case number 4038/01/14/FU/03/2008 with defendant Tegar Gemilang on this day, December 14th, 2022, open and declared for the prosecutor. Please the participant to sit in their respective places. In this case, are you accompanied by a legal counsel?
Yes, I accompanied by counsel.
Is it true that the sir of the legal counsel of the accused Tegar Gemilang tried to show the power of attorney? Is your legal counsel have a license, and is it legit?
Yes, it is true, legitimate, Your Majesty.
Well, for now the case will be heard in the District Court of Negeri Atas Awan. So everything that happened in this trial, please listen very carefully.
The defendant and the legal counsel are welcome into the courtroom.
Is the prosecutor ready for the charges? Has the defendants received a copy?
Your Majesty, I am already received the copy.
In this case, the defendant was charged with charges as follows. Article 2, Paragraph 1, Jo. Article 18 of Real Law Number 31 of 1999 concerning the eradication of corruption crimes, Jo. Law de Represekutor of Indonesia Number 20 of 2001 concerning amendments to Law Number 31 of 1999, Jo. Article 55, Paragraph 1 of the Criminal Code of Subsidiary, Article 3, Jo. Article 18 of Law R1 Number 31 of 1999 concerning the eradication of corruption crimes, Jo. Law of the Represekutor of Indonesia Number 20 of 2001 concerning amendments to Law Number 31 of 1999, Jo. Article 55, Paragraph 1 of the Criminal Code.
Have you entered into a letter of indictment that has been read by prosecutor before? How will the legal counsels make legal defense against the charges from the prosecutor's quote?
I understand, Your Majesty.
Yes, Your Majesty, I will do the defense.
Now please, read an exception from the legal advisor. For the prosecutor, how do you respond to the exoneration read by the legal counsel?
Sorry, Your Majesty. The exception read by the defendant legal counsel is too convoluted. I need time to resolve and understand what the mentioned legal counsel means in the experiential. According to us, the exception reached by the counsel defendant is not in accordance with the indictment of the case which has previously been read out by the prosecutor. What was read in the execution of legal advisor the accused mentioned, there is a party that has a competition in issuing news how to receive good to enclose the agreement even though Tegar Gemilang in doing the joint and directly confronted the Tawada Graha Company representative.
For the defendant and prosecutor, the injunctive relief of the law matches in accordance with the primary offense of Section 170, Ainnaya 2, number 1 of the Penal Code and the offense of subsidiary of Section 170, Ainnaya 21, number 1 of the Penal Code. You may file a challenge against this to the High Court. Then for that, please you later contact with the clerk. How about you, prosecutor? Are you ready with the charges and its demands?
I am ready, Your Majesty.
Alright then, please read out the charge.
Declaring the accused Tegar Gemilang guilty of jointly committing the corruption crime as is prosecutulated in Article 2, Paragraph 1, Article 18 of Law Number 31 of 1999, continuing the eradication of a criminal corruption as amended by Law Number 20, year 2001, considering amendments to Law Number 31 of 1999, continuing the eradication of corruption crimes, Article 55, subsection 1 of the Penal Code as in the first alternative indictment. 2. Sentences Tegar Gemilang to imprisonment for 15 years, reduced while the defendant in city custody with an order that the defendant be detained in detention center. 3. Pay a fine against the defendant in the amount of 200 million rupiah, subsidies of defendant for 6 months of confinement. 4. Tegar Gemilang must pay a replacement money of 5,988,227,272 rupiah in cents, charged jointly by the defendant. Tegar Gemilang is compensated by deposit money originating from Tegar Gemilang Tawada Graha Company in the amount of 1,700,000,000 rupiah. The deposit used to pay state financial loss Tegar Gemilang amount 2,540,000,000 rupiah, which totaled 5,988,227,272 rupiah. Then his property is confiscated by the prosecutor and auctioneer to cover the replacement money if the defendant doesn't have sufficient property for paying the replacement money, then sentenced to imprisonment for 3 years in prison.
Prosecutor, whether the witness are ready, please witness be called to the trial.
She is already here, Your Majesty.
To the first witness, Ms. Rahmani Nur Cahya, please enter the courtroom.
Are you healthy today and ready to go for trial?
Alhamdulillah, I am well, noble, and ready to attend the trial today.
Is it true that you are named Rahmani Nur Cahya, age 20, private employee occupation?
Yes, Your Majesty.
Did you know the defendant before? Is there a blood relationship with the defendant?
Yes, I know, Your Majesty, and I have no blood relationship with the defendant.
Alright, witness, in accordance with an Article 160 Alinea 3 of the Criminal Procedure Code, before being asked for the inquest, the witness will be sworn first according to their respective religions. For the witness, are you ready?
Yes, Your Majesty.
Now please repeat after me. I promise, as a witness, to give a true testimony, nothing but the truth, may God help me.
I promise as a witness to give true testimony, nothing but the truth, may God help me.
Member of the good you have been promised, so we ask that in giving information later, it must be in accordance with an actual information, because you can be sentenced in accordance with Article 3051, Alinea 2 of the Criminal Code if you provide false information with a maximum penalty of 10 months in imprisonment and a witness fine of 200,000 rupiah for corruption cases. What is your relationship with the defendant?
I, as his noble personal secretary.
How long have you known the defendant?
It's already 1 year ago, Your Majesty.
Now, what do you know about the defendant?
What I know, the defendant is named Tegar Gemilang. He works as the President Director of PT Surveyor Indonesia, and I am an employee of PT Indonesian Surveyor.
To the prosecutor, please ask the defendant questions.
Yes, Your Majesty. To the witness, explain what you know in this case.
I received an order to disburse the money in the cooperation agreement between PT Indonesia Surveyor and PT Tawadagraha on the audit of PT PLN's plant in the Java, Bali, Madura electricity system on October 31st.
For the prosecutor, is there still a question? Or sir of the legal advisor, is the defendant clear about the testimony of the witness?
I think enough of His Majesty the Chairman. To the second witness, Siti Najwa, please enter the courtroom.
Are you healthy today? And ready to go for trial?
Alhamdulillah, I am well noble and ready to attend today's trial.
Is it true that you are named Siti Najwa, age 22, working as a private employee?
Yes, Your Majesty.
Did you know the defendant before? Is there a blood relationship with the defendant?
Yes, I know Your Majesty and I am not related by blood to the accused.
Alright, witness in accordance with an Article 160 Alinea 3 of the Criminal Procedure Code, before being asked for the inquest, the witness will be sworn first with according to their respective religions. For the witness, are you ready?
Yes, Your Majesty.
Now please repeat after me. I promise, as a witness, to give a true testimony, nothing but the truth, may God help me.
I promise as a witness to give true testimony, none other than the real, my God help me.
Member of the good you have been promised, so we ask that in giving information later, it must be in accordance with an actual information, because you can be sentenced in accordance with Article 3051, Alinea 2 of the Criminal Code if you provide false information with a maximum penalty of 10 months in imprisonment and a witness fine of 200,000 rupiah for corruption cases. What is your relationship with the defendant?
I am only his ordinary friend.
How long have you known the defendant?
Already a year more ago, His Majesty.
Now, what do you know about the defendant?
I asked the Secretary of Accused record all the scheduled meeting. It was noted that the defendant had a meeting with representatives of the PT Tawadagraha in the matter of signing the minutes of handover of goods that had been proven to be false.
To the prosecutor, please ask the defendant questions.
Yes, Your Majesty. To the witness, explain what you know in this case.
There is another one. Among them are software components with quantity of 89 pieces worth 38 million, and also 7 units of advanced printers worth 30 million.
For the prosecutor, is there still a question or serve of the legal advisor? Is the defendant clear about the testimony of the witness?
I think enough of His Majesty the Chairman.
Yes. Next, the defense of the accused. Please, legal counsel from Tegar Gemilang.
Thank you, Your Majesty the Law Assembly that we honor. Prosecutor and Your Majesty's trial. May we plead with the tribunal examining and adjudicating this case so that 1. Declare the defendant not validly and convincingly proven according to law, committing the criminal act charged in the indictment. 2. Acquitting the defendant of the primary charge and the indictment in accordance with Article 191, Paragraph 1 of the Criminal Procedure Code, or at least releasing the defendant from all legal claims in accordance with Article 119(1), Paragraph 2 of the Criminal Procedure Code. 3. Restore the ability of the good name of the defendant's dignity and dignity to its original position. 4. Charge the state with the cause of the case. Or, if the law tribunal thinks otherwise, please make a fair decision in accordance with the provisions of the applicable law. Thanks.
Thank you. Does the prosecutor understand? And is there any evidence?
There is a noble one. I have evidence that in this trial, the prosecutor has submitted evidence in the form of check, a sum of gold, a passbook.
The next reading of the judgment and verdict for the accused by the member judge, based on the records of the hearing earlier, then the present agenda will be continued with the reading of the judgment.
Held that the accused Tegar Gemilang proved lawfully and conclusively guilty of the charge, sentenced to 10 years imprisonment, charged to pay compensation for state losses of 200 million rupiah.
Objection! Hold it!
But sir, you can't be bothered.
Apologize, Your Majesty, but according to the testimony given by the witness about the forgery of the signing, so I sue the accused under Article 263 subsection 1 of the Penal Code on forgery of signatures. Therefore, I demand an additional 4 years imprisonment and a fine 80 million rupiah in damage.
Objection!
80 million? Your Majesty, this is nonsense!
Objection!
Your Majesty, he has made our company almost bankrupt.
Quiet! To a legal counsel, is there a defense of the allegation from the prosecutors?
Objection!
There's another one. I think there's discrepancy here. The prosecutor charged the defendant with Article 263, Paragraph 1 of the Penal Code for forgery of the signatures with a fine of 18 million, where I don't think the items that are in the agreement cost that much.
To the witness, Siti Najwa, a secretary of the aggrieved company, is there any information about the details of the forged item?
You can have it, my Majesty.
Take that!
Alright then. To the prosecutors, is there any defense?
None, Your Majesty.
Are there any testimonies, allegations, or pleadings on the part of the witness and the prosecutor?
There is another one because the prosecution allegation have imposing fines on the accused, which is detrimental to the defendant's psyche. Therefore, I demand a deduction of the defendant's sentence from Article 216(3), Paragraph 1 of the Penal Code for 2 years, and thus the fine filed by the prosecutor in accordance with laws received by Tawada Graha Company.
Alright, based on the record of the hearing, the president's agenda will be followed by the reading of the verdict. Therefore, the tribunal held that the accused Tegar Gemilang was validly and conclusively proved guilty of the charge of the sentence to 12 years imprisonment, charged to pay compensation for state and company losses in the amount of 268 million rupiah.